We talk about medical negligence. From a legal perspective, negligence has a very specific meaning. When you say that someone has been negligent, you mean that that person has not acted in the manner that a reasonable professional in that position would have acted. So a reasonable doctor would have acted differently from the way in which this doctor who is accused of negligence has acted. So it's actually important to understand that as a starting point. The terms like this doctor was negligent shouldn't be sort of thrown around as if they don't have any content. And I think Dr. Chetty had pointed out as well about loose terminology, terms like botched, terms like killed. When we talk about defamation law, the words that you choose are really, really important, because those words in your article or in your broadcast are going to be individually scrutinized to understand, well, what do they actually mean? What would a member of the public who hears those words that you chose understand you to be alleging about that doctor? So the legal risk that you face, now having talked about the language issue, the legal risk that you face is one of three things. One is a defamation claim, which would happen in court. The second one would be a press council complaint if it's a print media that's a member of the press council. The third one is a BCCSA complaint, or alternatively, if you haven't subscribed to the Broadcast Complaints Commission, potentially a complaint to ICASA's Complaints and Compliance Committee. So those are the three legal risks that you would be facing. But in essence, from a legal perspective, if you publish a statement that a doctor has been negligent or is accused of negligence by a patient or the patient's family, that is understood to be a defamatory statement because it has an impact on their reputation. And the reputational harm is potentially very severe because it could lead to the end of that doctor's career, it could lead to the end of their business as the doctor, etc., as members of the public would choose to avoid them even before they are found guilty in any court kind of process or an HPCSA process, simply based on your reportage. So from a defamation legal point of view, that allegation that a doctor has misconducted themselves from a medical negligence point of view is understood to be defamatory. From the BCCSA and press code point of view, you are required to ensure that whatever you publish is truthful, it's accurate, it's fair, that statements are not presented as a fact if they are based on rumors or suppositions, or if it's unclear. So those are the aspects of those professional codes that you need to be concerned about. Also, the press code specifically talks about exercising care when you're making an allegation that will impact on the dignity or reputation of an individual, which obviously an allegation of medical negligence will impact on the reputation and dignity of the doctor concerned. So that's the risk. How do you mitigate against that risk, and who's liable for that risk? The liability rests on every single person who is part of the chain of publication. So the patient who approaches you and says, I went to Dr. So-and-so and my procedure was botched, that person is making a defamatory allegation, they are liable. The journalist who writes the article and is therefore responsible as part of the chain of publication, they are liable. The publisher of that particular story or the broadcaster. So if we're talking about a print media organization, that print media organization. If we're talking about a broadcast organization, if it's a television station, a radio station, that organization. And strictly speaking, it can even go as far in the print context as the store that carries copies of that newspaper, but that never really happens. But in theory, it could happen. So everyone who's involved in the chain of publication, you must never as a journalist believe that by virtue of working for the newspaper, you can't be sued in your personal capacity. However, what often happens in practice, certainly that I've seen, is that your publication would take responsibility for it and they would effectively indemnify you because they would pay out the legal fees and they would pay out whatever damages is awarded against you. I've certainly never encountered a scenario where the broadcaster or the publication will throw the journalist under the bus and say, you go and deal with it yourself. I haven't yet come across that, which is not to say you shouldn't be concerned, because of course your reputation as a journalist is also on the line. So what are your defenses then? How should you be mitigating against this particular type of risk? So there are three potential defenses that you need to keep in mind when you are writing a story of any kind that is defamatory, and certainly a medical negligence one. The first, most obvious one will be truth and public interest. Is what I'm going to publish going to be the truth, and is it in the public interest? Well, I would argue a story about medical negligence is almost always in the public interest, because if a doctor is misconducting themselves, any member of the public can fall into the hands of that doctor and be harmed. And so it is in the interest of the public for the public to be aware that this has taken place. That's a different question as to whether it is true or not, of course. And it's a different question as to the ethics of your timing and when you choose to publish. And I think here I just want to pause to say that ethics and law are not the same thing. The law may often allow you to go much further than what your ethics might potentially allow you to go. But in law, if it's in the public interest, then you can publish it. You don't have to wait until a particular point. Then secondly, we're looking at, is it true? When we look at truth, we're talking about truth or substantial truth. Substantial truth doesn't mean true in every single detail. For example, if you say, well, the patient arrived at the hospital at 6 and the doctor only came to see them at 6:30, and that 30-minute time difference didn't make a substantial difference to the outcome, then the fact that you made a mistake in your article and says it was at 6 or at 6:30 is not really relevant. However, if that 30-minute time difference is crucial to the outcome for that patient, then it is a substantial inaccuracy and untruth. So the truth is not truth in 100% detail, but it is substantial truth. The difficulty, of course, with truth, both in court and even if you are at the BCCSA or at the press council, is that it's a little bit more difficult to establish that something happened as a fact. And I would certainly advise that when we're talking about medical negligence, it's a very specialized area. Medicine is a specialized area. That's why people train for 6 years and then go and do community service and all of these other things to become doctors. So it's a very difficult thing for you as a journalist to stand and say, well, I've heard this and it's medical negligence. I think it would have to be the most glaringly obvious of things in order for you as the journalist to really truthfully be in a position to make that type of expert conclusion. The more complex something is, the more careful you need to be as to a conclusion that this is what actually happened. And that's why I would always advise that when you're dealing with an allegation of medical negligence, you should be careful to see whether you can find an independent doctor who can comment and advise you, even if they don't want to go on the record, because often professionals will be reluctant to go on the record against another professional. So they may wish to have their identity, concealed as a source, which as a journalist, you're also entitled to have confidential sources and to have that protected constitutionally. So I would definitely advise, seek the input of independent medical practitioners to say, what the facts are that this patient alleges. Yes, it sounds like negligence. Don't just go out there on a limb on your own because you think it's obvious that the doctor shouldn't have done this or should have done this. And I think the other important thing for you to consider as a journalist is that the mere fact that someone has died or has been injured or permanently harmed in some way does not equate to negligence. And that's why terminology like routine operation is questionable from a legal perspective, because someone can go in for a routine operation. And if you've ever been in hospital, the doctors will tell you every operation is potentially life-threatening, because if something goes wrong that is not expected, you could end up being harmed. So to use terminology like it was a routine operation, but yet the child died, doesn't prove anything, that it should have been simple and should have been obvious. And that's why it's really important for you as a journalist to get that expert input. So that's the issue of truth. Secondly, we talk about in defamation law, reasonable publication. And there's also provision made for this as well in the press code and the BCCSA. It doesn't state it in the BCCSA code, but in the rulings of the BCCSA has also taken into account the issue of reasonable publication. So what does this mean? It means even if I can't prove definitively that it is true, what I have written or published is true, can I show that I have been reasonable as a journalist in the manner in which I have taken steps to put together this story? So how do you show that you were reasonable? There are a number of things that the courts will consider to look at whether you were reasonable. One of them is it balanced? The tone, what is it that you're actually saying? And that goes back to my point at the beginning about what is the language that you're using? If you're going to use emotive language like this was a botched operation, this doctor is a well-known maverick, numerous allegations of XYZ and so forth, then even if you try to couch it as allegations, the overall impression that might be created by your piece is that the person is actually a problem, should be avoided, is suspicious, or has even done it, whatever the patient says they've done. So you need to be very careful about the tone and the language that you use. The less evidence you have, the more careful you have to be about the tone and what you're actually saying the doctor has done. Secondly, is the issue of how have you taken steps to verify? And this is where my previous advice about try to get another doctor who's an expert to look into the matter and tell you what they think about it. For example, I've seen stories in the past about someone who's putting themselves out there to say, I'm a plastic surgeon, but many of the people that have been to them end up having to go back for multiple corrective procedures, for example. Then how many sources do you have? Do you have one disgruntled individual, or do you have 2 or 3 or 4 or 5 people telling you the same story? You've got a pattern that's much stronger than if you've got one person and one incident that's being put under a microscope. So steps taken to verify. How reliable is your source? If you've got a source coming to you, for example, if you've got a nurse coming to you from a hospital and saying, here are medical records that I can show you confidentially that shows that this was reported to the doctor, but they didn't act. And this is someone who's close to it, who is treating the patient, etc. So how reliable is your actual source is very important. If it's just the patient coming to you and saying, I took my child there and my child died, that's not a source. That's someone who's disgruntled and who says this happened. And how do you then verify what they say? And then the next point is this issue of right of reply. Very, very important. Have you given the doctor, the hospital, the nurse, the service provider, an opportunity to put their side on record? But one thing that's important to remember when it comes to medical negligence, it's not that easy for a hospital or a doctor or any healthcare provider to fully respond to allegations of negligence in the media. And the reason for that is that ethically, they are not allowed to disclose the details of a medical process to third parties. Even from a legal point of view, in terms of the National Health Act, a doctor or a hospital can't simply pull out the file on a patient and start showing you as you would expect. And of course, as a journalist, this kind of goes against one's instincts, right? Usually you're expecting the person who you're giving the right of reply, if they're playing open cards, to come out and say, this is the detail of what happened. If I've got documents, I can even show you the documents. A doctor and a hospital can't do that because it's illegal unless you have written consent from the person who's making the allegation that they received the problematic treatment. That doctor cannot provide you with the detail. And I think that's really important as a journalist, because often what happens, and I mean, I've worked with journalists for over a decade, what often happens is that when you give someone a right of reply and they appear to be cagey and they say, oh, it's sub judice and so forth, then there's a cloud of suspicion over that they don't want to respond. But with doctors and hospitals, it's a bit different because they can't really respond. So you need to think about how you position their failure to respond in the article, and it shouldn't be positioned as some kind of stonewalling by them. So that's reasonable publication. The last point I want to make is on fair comment. Now, fair comment is the defense that allows you to publish an opinion. This is where you get your opinion pieces and so forth. What is really important about fair comment, though, is that it must be based on facts that are true or substantially true. And when you're dealing with a defamation case in court, and even when you're dealing with a BCCSA matter, the Press Council doesn't really mention this, but in both court and the BCCSA, it's a clear principle that the facts on which your comment is based must also be referred to or broadly known. So you can't simply say, well, I think that doctor is absolutely shocking. When is the HPSA going to deal with him? Without saying why. What are the facts on which you base it? And I would really caution journalists on the issue of fair comment and medical negligence. I think this links back to my first point about negligence being an issue of expertise and it being potentially problematic for you to express an opinion on facts that you may not actually understand. And also, if you do choose to go and then express that opinion on those facts, to what extent and what detail do you then present those facts in your article? And the reason why the presentation of facts in the story is important is because members of the public must draw their own opinion and conclusion of the facts. They mustn't take your opinion as a fact. They must take the facts as the facts and your opinion as an opinion. Very, very important if you go down the opinion route, that not only must your facts be true, adequately stated, But even your opinion must be couched as an opinion and not as a fact. And it's highly questionable as to whether, when you say someone was negligent in the performance of their duties as a doctor, there will always be debate as to whether that's a fact or an opinion. So it's definitely an area for caution there as well.